Very much, Daniela, and good afternoon to all the attendees, to all the presidents and members of all our sister academies. I would also like to bring our most welcoming salutation to the honorary president of this conference, Monsieur le Professeur Pelé, and also to the chair committee presided by the executive president Oscar Maurtuara de Romaña and the chief coordinator Gonzalo Tello. In behalf of the Colombian Academy of International Law, we have prepared somewhat a panel that constitutes from novel but also classical approaches. And we would like to present you with recent research developed by our members, but also as the very welcoming and interesting caveat that was present in the program, we will also like to create an ambience, create the possibility for discussion. So instead of going very deep into the issues of certain recent litigation as was presented in our written manifest of the panel, I would like to give some lines, some food for thought that could be used for us to entertain a further discussion by the beginning of the panel. I would like to share some slides. I think they are working now, and I hope they are being seen by the whole auditorium. When it comes to international law and technologies, there is, of course, an ever-growing, a very fast evolving debate regarding what are we really speaking of. And thanks to the organization of the panels, I think that today it has been covered, or at least the conference had covered, one of the most complex and most controversial recently issues, which is cyber operations. Nonetheless, and beginning by my own fascination in the topic, I would like to say that there are at least 5 principal new technologies, 5 new realms of technology that are really linked to the development of IHL, but also to the development of international settlement of disputes. Those are the ones of unmanned vehicles, the issue of autonomous or semi-autonomous weapons, the very heated debate of the involvement of international and of artificial intelligence in the use of international law, because it is being used not only to create and to make weapons more diverse and more complex, but it is also being used in dispute settlement. Also the ways in which machine learning can affect the behavior of the instruments of war. And finally, as was discussed in a previous panel, the realm of civil operations and, of course, their consequences in the rule of international humanitarian law. In this very short presentation, and on behalf of our initial idea of giving food for thought and setting the tone of the discussion, I would like to focus on unmanned vehicles and autonomous weapons, but also in the general sense in drones, because drones, as I will try to explain further on, are present in many other realms of international law than the ones that are being discussed. This photograph that you are seeing projected is of an Argentinian news outlet just yesterday, and I think that the video that I will describe to you summarizes very well the issues of unmanned vehicles and the recent attempts of being regulated under international humanitarian law. In this video, a toy, because it was not a professional drone, a toy drone was used to launch a hand grenade to Russian combatants in occupied Ukrainian territory. During the video, you can see 3 instances of different principles of international humanitarian law being involved with drones and therefore with recent unregulated technologies. The first is the use of civilian technology opposed to well-regulated and to clarified military technology in the conflict. Because those drones, nonetheless being used for war activities, are part of the realm of what it is for a moment, civilian objects. Nonetheless, there is the issue of, for example, what is occurring in those conflicts, the donation of civilian objects to comply with activities of war. That's the first element. The second element is the fact that this drone, by being equipped with a camera and by being piloted, by being directed by a Ukrainian soldier, was able to perform two actions. The first, to throw the grenade in front of the Russian combatants, but also to follow up the decisions afterwards. The grenade did not kill the combatants, but because it landed next to them, near the zone where they were occupying, but it was able to hurt two of the Russian combatants. Thanks to the video and to the manned activity during the launching, the Ukrainian soldier was able to comply with international humanitarian law because he was able to apply proportionality, necessity, and other principles of international law to the action. He was able, thanks to the video of this simple toy, to decide, as the video further shows, if another attack was necessary. It was not, because the combatant was, or the arm, he was out of the possibility to keep attacking. So further on, he was able to follow up the destiny of this wounded combatant and decide that since the threat had been successfully diminished, there should not be any more attacks. This situation, which in this case in a news outlet yesterday was thankfully in compliance with international law, shows us the different and the complexities that an unmanned vehicle can have. Because if we're talking about autonomous weapons or unmanned vehicles, there is no assurance either from technology or either from the law that the pre-codification of the behavior of the instrument can make such decision. How can you pre-program a drone that is aimed to a pre-codified target to assess by the looks of the way in which the bomb was thrown, by the ways in which you can see by video that the combatant was wounded, to decide either by artificial intelligence, either by a pre-programmed function, a prompt, if he should stop attacking or if the aggression was fully diminished. That's the main and the biggest danger of unmanned, pre-programmed and autonomous vehicles being used in conflict today. Therefore, we totally agree with certain recent manifestations by the ICRC in which they propose two main principles that can be applied to this situation in which the complex relation between drones and international humanitarian law can be understood. The first principle should be that nothing in the process of aggression, in the process of using the weapon, should be totally unmanned and should be totally left to the weapon to decide. But also that the pre-codification of the weapon, of the instrument, must comply fully with certain principles of humanity that should include the prompt of being stopped by the supervisor, by the soldier that is using the weapon, in order to make quick and assertive decisions that could, in certain cases, procure with the fulfillment of international humanitarian law goals. Now, I would like to change a little bit the approach of this presentation and try to discuss something that I noticed when I was researching in order to create our panel. When we approach drones and we approach the topic of the conference, new technologies and international humanitarian law, it is true that it is an excessive and, of course, necessary amount of scholarly work regarding international humanitarian law, the lawful or unlawful uses of weapons. But I think that technologies as unmanned vehicles, drones, artificial intelligence, and others do have a place, a broader place in the realm of public international law or general international law. If I were to show you these two pictures and ask you to guess to which issue of international law they belong, Probably you will try to guess that they are being used by combatants in a certain conflict. They are being used to identify civilian or military targets. Those are common assumptions of the way we think of drones in the realm of international law and international humanitarian law. But the truth is that drones are also present in dispute settlement scenarios. They are also present in the ways in which international criminal law courts are assessing evidence. They are also present in scenarios in which international law is using experts, scientific experts, geographical experts, to solve disputes as wide as as frontier disputes are delimitation disputes. So those pictures correspond, and that's the point, to a very classical non-IHL issue and to an international dispute settlement scenario. Those pictures correspond to the drones used in the Costa Rica versus Nicaragua litigation between 2014 and 2017. I, as an international lawyer, I have to tell you that I was absolutely starstruck by experience that I had in The Hague in July the 3rd in 2017. I went to assist as a public hearing to the procedures between Costa Rica and Nicaragua in two cases that were conjoined by the court. And I was expecting, as in many other occasions, to find the court addressing international law in a very classical way. But this day was different. This day, the court was debating drone footage. This day, the court and the parties were addressing evidence that was obtained by technology, and the most important mean of conviction in the whole hearing was the pictures taken by drones. Both the experts and also the parties, the Costa Rican delegation and the Nicaraguan delegation, had used profoundly drones to establish the merits of the case, to establish evidence. And I think that has to give us a different way of thought. It has to allow us to understand technology and drones in the realm of international law in a more broader way. If we were to discuss how do they belong to international law besides IHL, and if we were to assess them as an evidentiary issue, we should start asking questions as, how do we assess the legality of proofs obtained by drones? How do we assess issues very classical to international law in the realm of dispute settlement as the égalité des armes? Do every state has access to drones in the terms of accessing to them for evidence? If the litigation is asymmetrical, as it is in many rounds of international law, for example, individuals against states, how can we assure that if drones and technology become an evidentiary mean, how can we use them in a way that it's fulfilling for both parties? This comes to me to the next example. Very recently, the Ukrainian cinematic industry has developed a very interesting documentary called Follow Me. It shows how Ukrainian forces in the terrain were able to save the life of a woman that was hurt during an attack in the Donetsk area, because their car made a wrong turn to a zone where the conflict was active, and Russian occupation forces attacked the civilian vehicle. The Ukrainian forces were able to use a unmanned vehicle, a drone, put a sticker that said, "Follow me," and the woman was able to follow the drone and save her lives because they were being attacked in a violation of IHL by Russian forces in occupation. Following, the same technology unit was able to intercept communications of the Russians, and the Russian soldier was calling his wife and telling her that he had shot a man and that he had shot a civilian vehicle. This proves that technology and drones are not only to be understood as threats to international humanitarian law and to be understood as foes, as ghosts, as terrors in international law. They are playing a very complex and a very relevant role in public order, in the fight against criminality, in the obtain of evidence, and also in the ways in which international courts think, just as in the case of Costa Rica and Nicaragua, which many of its complex questions was solved through draws. Therefore, I would like to leave the table and the floor to my co-panelists, and also some food for thought for the attendees by the next following up questions. How can these new technologies can only not be understood as a threat to international law, but also as a tool for parties in dispute settlement and also for experts? How can we reinvent the realm of evidentiary means and means of convictions for states that use these technologies during plaidoirs, during scientific assessment of facts? How can and how long do we need to regulate the programming of preconditioned conducts of drones? But most especially, how can we rethink about the evidentiary element of technology in international law, since now, and also in developing countries, their most complex litigations, as it was in Costa Rica and Nicaragua, are deeply intertwined with the use of technology. Thank you very much.
Thank you very much, Professor Arévalo. Now